Welcome to Simple Understanding Channel. In this video, we move to the second major section of the Certified Fraud Examiner exam, Law. This section destroys candidates who believe that memorizing legal definitions is enough. The CFE exam does not test legal memory. It tests legal reasoning, evidence evaluation, rights, procedures, and the ability to think like an investigator working inside the justice system. The law section trains you to understand the difference between criminal and civil fraud, how burden of proof changes the entire strategy of a case, how fraud is legally defined, how statutes such as mail and wire fraud are applied, how evidence is admitted or rejected, how suspects and whistleblowers are protected, how searches and confessions are regulated, how expert testimony is evaluated, how damages are recovered, and what legal and ethical responsibilities a fraud examiner carries. In short, this module teaches you how fraud moves from suspicion to court, from evidence to judgment, and from investigation to legal accountability. On Simple Understanding Channel, you will find a complete free CFE course that covers all 4 sections, all modules, and all high-yield topics, explained in clear and simple language with practical examples, so you can truly grasp the key concepts, not just memorize them. And for those who want a full structured preparation, the link in the description contains our complete CFE study packages. Bundle 1 includes a complete study guide covering all 4 sections, a full list of formulas, and step-by-step explanation of all mathematical and financial calculations you need for the exam. Bundle 2 includes more than 3,500 multiple-choice questions covering conceptual, scenario-based, legal, and quantitative topics, all with detailed answer explanations that train you to think like the examiner. Bundle 3 includes more than 1,300 flashcards with key terms, definitions, fraud schemes, legal concepts, investigation techniques, and professional standards. This series of videos will walk you through the entire CFE syllabus section by section, using the same mental structure the examiners use when they design the questions. 1. Difference between criminal and civil fraud. Criminal fraud involves actions that violate criminal law and may result in imprisonment, fines, or both, while civil fraud involves private disputes where the goal is financial compensation or contract remedies. The CFE exam tests your ability to distinguish objectives, procedures, and standards between the two systems. Criminal cases focus on punishment and public interest, while civil cases focus on restoring losses and resolving disputes between parties. Understanding this difference determines how evidence is gathered, how investigators cooperate with prosecutors, and how cases are pursued. In real life, a company executive who falsifies financial statements may face criminal charges by the state for fraud, while investors may file civil lawsuits seeking compensation for their losses. The same act can trigger both paths, but the legal process, burden of proof, and consequences are completely different. 2. Burden of proof. Preponderance of evidence versus beyond reasonable doubt. Burden of proof defines how convincing the evidence must be to win a case. In civil fraud, the standard is preponderance of the evidence, meaning more likely than not. In criminal fraud, the standard is beyond reasonable doubt, meaning near certainty. The CFE exam frequently tests this distinction because it affects how much evidence is required, how investigators document cases, and whether a case can proceed to prosecution. For example, a company may terminate an employee for fraud based on strong circumstantial evidence that meets civil standards, yet prosecutors may decline criminal charges because the same evidence does not meet the higher criminal threshold. Fraud examiners must know which standard applies and how strong the proof must be. 3. Elements of fraud under common law. Under common law, fraud requires specific elements: a material misrepresentation, knowledge of falsity, intent to deceive, reliance by the victim, and resulting damages. The exam expects you to understand that all elements must exist for fraud to be legally established. Missing even one element can collapse a case. In real cases, if a manager provides false financial information, but investors did not rely on it when making decisions, the legal definition of fraud may not be satisfied, even though unethical behavior occurred. Fraud examiners must gather evidence that proves each element, not just wrongdoing. 4. Fraud-related statutes: mail fraud, wire fraud, conspiracy. Fraud-related statutes define specific criminal offenses and expand jurisdiction. Mail and wire fraud laws criminalize the use of communication systems to commit schemes to defraud, while conspiracy laws criminalize agreements to commit fraud even if the act is not completed. The exam tests your understanding of how intent, communication, and coordination trigger these statutes. In common real-world examples, using email to send false invoices or electronic contracts, even if the money is not yet stolen, the use of communication systems in furtherance of a scheme can constitute wire fraud. When multiple people coordinate roles, conspiracy charges may apply even before the fraud is fully executed. 5. Rights of the accused: due process and self-incrimination. The rights of the accused protect individuals from unlawful investigation practices and forced confessions. The exam focuses on due process, the right to remain silent, protection against self-incrimination, and fair treatment during questioning. Fraud examiners must understand these rights to avoid contaminating evidence and violating legal procedures. In practice, if a suspect is coerced into confessing or questioned without respecting legal protections, the entire confession may be ruled inadmissible in court. This can destroy an otherwise strong case. Proper interview technique and respect for legal boundaries are therefore critical for legally defensible investigations. 6. Rights of the accuser and whistleblower protections. The legal system provides protection to individuals who report fraud in good faith, shielding them from retaliation, wrongful termination, and harassment. The CFE exam tests your understanding of how whistleblower laws encourage reporting, protect identity, and provide legal remedies when retaliation occurs. Fraud examiners must understand both the rights of the reporting party and the legal obligations of organizations to investigate and protect them. In real cases, employees who report financial misconduct may face pressure, demotion, or dismissal. Whistleblower protection laws allow them to seek legal remedies and, in some jurisdictions, financial rewards. Organizations that fail to protect whistleblowers may face lawsuits, regulatory penalties, and reputational damage. 7. Rules of evidence: relevance, admissibility, and hearsay. Evidence must meet legal standards to be accepted in court. The exam emphasizes relevance, meaning the evidence must relate directly to the facts of the case, admissibility, meaning it must be legally obtained and properly presented, and hearsay, which is generally excluded unless an exception applies. Understanding these rules ensures that investigations produce evidence that can withstand legal scrutiny. In practice, a document proving unauthorized payments may be relevant but inadmissible if obtained illegally. Similarly, a statement repeating what someone else said may be considered hearsay and excluded unless supported by direct testimony or a recognized exception.
Quick reminder, if you're finding this helpful, don't forget to like, subscribe, and share with anyone who may benefit. Your support really makes a difference. Let's get back to it.
8. Direct versus circumstantial evidence. Direct evidence directly proves a fact, such as an eyewitness account or a confession, while circumstantial evidence requires inference, such as financial records showing unexplained wealth. The exam tests your ability to distinguish between these types and understand that both can be equally powerful when properly corroborated. For example, video footage of an employee stealing cash is direct evidence. A pattern of unusual bank deposits matching missing funds is circumstantial evidence. Courts often rely on a combination of both to establish guilt. 9. Chain of custody. Chain of custody documents the handling of evidence from collection to court presentation. The exam highlights its importance in ensuring evidence integrity and preventing tampering claims. Any break in the chain can render evidence unreliable or inadmissible. In real investigations, digital files, documents, and physical items must be logged, stored securely, and transferred with documentation. Failure to maintain a clear chain of custody can allow defense attorneys to challenge the authenticity of the evidence. 10. Search and seizure limitations. Search and seizure laws restrict how evidence may be obtained, protecting individuals from unreasonable intrusion. The exam tests your ability to understand consent, warrants, scope of searches, and the exclusionary rule, which prevents illegally obtained evidence from being used in court. For example, seizing personal emails without proper authorization may violate privacy rights, leading to suppression of key evidence. Fraud examiners must work within legal boundaries to ensure investigations remain lawful and defensible. 11. Privileges. Attorney-client and work product. Legal privilege protects certain communications from disclosure in court. The most important for fraud examiners are attorney-client privilege and work product doctrine. Attorney-client privilege protects confidential communications between a lawyer and client made for the purpose of legal advice. Work product protects materials prepared in anticipation of litigation. The CFE exam tests your ability to recognize when documents and communications are protected and when privilege is waived, such as when third parties are included or when communications are used for business rather than legal purposes. In practice, emails between management and in-house counsel discussing legal strategy may be protected, but the same emails copied to non-legal staff may lose privilege. Fraud examiners must know when they can access documents and when legal counsel must be involved to avoid violating protected communications. 12. Confessions and voluntariness. For a confession to be admissible, it must be voluntary and free from coercion, threats, or improper promises. The exam focuses on understanding that physical force, psychological pressure, deception about legal rights, or denial of basic needs can render a confession invalid. Fraud examiners must conduct interviews in a manner that respects legal safeguards and ensures statements are legally defensible. In real investigations, if a suspect is pressured into confessing through intimidation or false promises of leniency, the confession may be excluded in court. Even a truthful confession can become unusable if obtained improperly, potentially destroying the entire case. 13. Expert witness standards. Daubert versus Fry. Expert testimony must meet specific standards to be accepted in court. The Fry standard focuses on whether the expert's methods are generally accepted in the relevant scientific community, while the Daubert standard evaluates reliability, testing, peer review, error rates, and methodology. The CFE exam tests your understanding of when expert opinions are admissible and how courts assess professional qualifications and methods. In real cases, a forensic accountant may be excluded as an expert if their methodology is not scientifically sound or widely accepted. Fraud examiners who testify must ensure their analysis follows recognized standards and can withstand judicial scrutiny. 14. Civil remedies for fraud. Damages, rescission, restitution. Civil fraud cases aim to compensate victims and restore them to their original position. The exam emphasizes remedies such as compensatory damages, punitive damages, rescission of contracts, and restitution. Understanding these remedies helps fraud examiners quantify losses and support legal claims. For example, a victim of investment fraud may seek monetary compensation, cancellation of fraudulent contracts, and recovery of misappropriated funds. Loss calculation and documentation prepared by fraud examiners often form the basis for these legal remedies. 15. Ethical and legal liability of fraud examiners. Fraud examiners themselves are subject to legal and ethical standards. The exam tests knowledge of professional responsibility, confidentiality, objectivity, conflict of interest, and the consequences of negligence or misconduct. Examiners must follow due process, respect rights, and avoid defamation, invasion of privacy, and unauthorized practice of law. In real practice, an examiner who discloses confidential information, conducts unlawful searches, or makes unsupported accusations may face lawsuits, disciplinary action, and loss of professional credentials. Ethical compliance is therefore not optional, it is a core professional obligation.
This completes Module 2, Law. You now understand how fraud is defined and proven, the difference between criminal and civil cases, how burden of proof works, how evidence is evaluated, how rights and procedures are protected, and what legal and ethical responsibilities a fraud examiner carries. On Simple Understanding channel, you will find a complete free CFE course covering all 4 sections with clear explanations and practical examples. For full structured preparation, the link in the description contains our complete CFE study packages designed to help you pass from the first attempt. In the next video, we move to Module 3, Investigations, where we cover how fraud cases are planned, evidence is collected, interviews are conducted, money is traced, and reports are prepared. Subscribe to the channel, like and share this video, and comment below if you want the full CFE series to continue.